Hi everyone, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I want to talk about a record-breaking verdict out of Colorado for $12.4 million, a landmark verdict, and it's against Vail Resorts, and it involves skiing. A lady was paralyzed after she fell from a mountain resort chairlift in 2022, and her lawsuit was against the owner, Vail Resorts, and she prevailed at the Colorado Supreme Court and then again with a jury decision this week. It just came down on September 4th, yesterday. So let's talk about this case. This is an interesting case for many reasons. What happened was there was a Paradise Express high-speed quad built by Poma and installed at Crested Butte Mountain in 1994. And so she fell from this chairlift in 2022. The defendant argued that whenever you use the resort, you ski, you sign a liability waiver. So you're basically giving them blanket immunity from lawsuits. And she was only 16 and she was on a ski trip with an Oklahoma church group. And she slipped from the express lift at this mountain in March of 2022. And her family, as well as her attorneys, argued that the lift operators at the resort were negligent because they failed to stop the chair when, her name was Annie, when Annie did not load properly. So I guess she's waiting for the lift, you know how the lift comes behind you, and then the lift grabs her, there's somebody else on the lift, but the lift doesn't take her properly. Maybe she's like hanging, and they just continue and let it go up, right? And then she ends up falling, and then she had really severe injuries, including paralysis, right? She got paralyzed. Her father tried to hold his daughter, I guess he was there too, but she fell 30 feet to the hard-packed snow, shattering the C7 vertebra in her back and leaving her unable to walk again. So a terrible, tragic, just horrific story. But see, that goes to an interesting issue, because when you sign that liability waiver, you're basically saying, well, I'm gonna give you carte blanche. I'm not gonna sue you because it's a risk of skiing, right? Skiing has risks. If I ski, I could fall, somebody else could run into me, I could run into somebody else. It's a sport, it's a dangerous sport. But you don't really sign a waiver to say that, hey, if I don't load on a seat properly, you can just let the chairlift keep going with me hanging, and then somebody has to try to lift me up and put my butt on the seat safely. But if they don't, I could fall 30 feet and, So I don't really see the argument of the defendant. I think that's clear negligence on the part of the employee of the resort who was supposed to stop the chairlift. They'll argue that they were immune to negligence, citing the Colorado Ski Safety Act, which requires skiers to follow several safety rules, including know-how on how to load chairlifts and caps lawsuits at $200,000, as well as a liability waiver that the family signed when they bought the 3-day pass. Now, the resort argument has worked for decades with very few court decisions siding with skiers who sue ski resorts. And the district judge in April of 2023 dismissed 2 of the claims citing this liability waiver, including the negligence per se claim, which involved the ski area's duty to keep the chairlift riders safe, and allegations that the lift operators at the resort violated the standards for chairlift safety created by the American National Standards Institute, or ANSI, and enforced by the Colorado Passenger Tramway Safety Board. So you see, like, the lawyer had to get like an expert, maybe a ski expert, that quoted these American National Safety Institute standards of chairlift safety. And then the Miller family appealed the decision to the Colorado Supreme Court, which in May of 2024 ruled that the standard click-through agreements used in every lift ticket sale, when they sell you the lift ticket, they have that standard click-through agreements. But he said they do not shield ski areas from all negligence, right? You could still sue for negligence despite those agreements. So we'd have to look at that decision to see the exact legal analysis, but that's very interesting because the same thing's happening with Uber, where they say, hey, if you use an Uber, you're not going to be able to sue us. You kind of like, it's also one of those click-through agreements. So this landmark high court ruling sent ripples through the recreation industry, including rafting outfitters, youth camp operators who were afraid that the decision could spike insurance costs, raise prices, and force recreation businesses to exclude young visitors. And the Colorado Supreme Court sent the case back to the district court for a jury trial, and the jury heard the simple negligence claims, and the jury of 6 listened to arguments for 9 days. And the jury did support the family's argument that the lift attendants violated safety standards. And after a day of deliberations, the jury awarded Annie $5.275 million for non-economic losses, $5.275 million for physical impairment, and $10.55 million for future economic losses. And the jury found that the mountain resort was not wholly responsible for the accident, reducing the $21.1 million award by 25% to $15.8 million. And the Colorado law caps non-economic losses at $690,000, so the total award was $12.4 million. But the actual verdict was 21. It's just, I guess they gave 25% to the 16-year-old, 75% to the lift operator who should have stopped the lift, and that's why it was lowered to 15. And then because Colorado has caps, the caps 690, so that's became 12.4 instead of 15.8. The jury's decision is a first ever crack in the armor provided to ski resorts by Liability Waivers and the Ski Safety Act. Those waivers have never protected recreational businesses from intentional or reckless misconduct, which is legally defined as gross negligence. But for decades, those businesses have used waivers to dismiss many claims by injured visitors who argued that rafting company or ski operators were guilty of lesser levels of negligence. And so the main argument in the Miller case was that Crested Butte Mountain Resort lift attendants violated ANSI safety regulations that were developed with the National Ski Areas Association. And the case focused on the duties of the lift attendants and the people who trained the first-year workers who were running the Paradise Lift on that day in March. So training, right? They didn't train these are first-year workers, so they're novices. But if you don't train them, then they're not going to know you have to stop the lift if somebody's like hanging off of it or not seated safely. And the jury did find that Crested Butte violated ANSI standards, and the violation of that standard was the cause of the injury. And that was the law firm who represented Annie. Because when you're on a lift, you are at the mercy of the resort operator, and even if you did not get on the lift properly, you should have every right to assume that the lift attendant is properly trained, paying attention, and is ready to do their job and stop the lift. And I see that, I ski myself, and I see that. I'm sometimes on a lift riding, and all of a sudden it jerks, and then it goes forward and back, and then all of a sudden you're stopped in midair and you're waiting, and it's probably because there's a little kid who couldn't get off the lift, and as he's getting off the lift, they have to help the little kid or whatever. So it stops for like a few seconds. Everybody's stopped and everybody's waiting 20 seconds, then it starts up again, and this time, they didn't stop it. And he said there's a difference between not loading a chairlift and you going 243 feet up the line and the chair not stopping until you are 30 feet above the ground. And he basically said the jury decision is the first and only verdict against the ski resort based on negligence per se claim through an ANSI standard. And Annie, who's now a second-year student studying music and psychology at a university, testified in the trial, as did her parents. And Vail was represented by a different firm and a big firm, a global firm, Brian Cave, and arguments on both sides revolved around interpretation and implementation of the resort industry ANSI standards for chairlift operations. And they basically said, we disagree with the decision, believe it was inconsistent with Colorado law. We recognize the personal toll this accident has taken on this family, and we wish her continued strength in her recovery, and that we remain committed to the highest standards in operations. I guess that's an interesting case. It's like a new case, right? A new law. It's always been that these liability waivers protect the ski resorts, but in this case, they said that no, you could have this verdict. So let us know what you think. Please like and subscribe to our channel. We are here for you. Our goal is helping serious injury victims and families. All the best. Bye-bye.